who owns property in the United States? A lot of Canadians do, and that can create some interesting complexities with regard to selling the property in the future, as well as from an estate planning point of view, if you die while you own the property in the United States. And so with me today to address these particular issues is David Alexander of Gross Schumann in Buffalo. Now, David has been practicing law for 50 years in New York and Florida. He serves as a foreign legal consultant in Ontario and Canada. His areas of practice include wills, estates and trusts, estate planning, administration, business counseling, corporate law, and taxation. He represents Canadian and other foreign corporations in the establishment of U.S. subsidiaries and their conduct of business in the U.S. He also represents Canadian and other foreign persons who purchase assets in the U.S. to effect asset preservation. And he also has great experience in securities regulation and compliance, and represents businesses in private or public financing, as well as in merger and acquisition transactions. David, you're a very seasoned lawyer. You have lots of experience, lots of wisdom to share. Thank you very much for being a guest on The Mayor of Money.
Rick, nice to see you in person virtually.
It's good to see you. And as we're taping this today, it's the kickoff of the NFL season with the Buffalo Bills playing in Los Angeles against the Rams, the defending Super Bowl champions. And we know who we both want to win tonight. So let's keep our fingers crossed. That's a good launch for the Bills this season.
Right. Okay.
So real estate. So there's many Canadians, people out west own a lot of properties in Arizona. People out in Ontario, Quebec own a lot of properties in Florida. And my wife and I, my wife Cheryl and I bought a fractional ownership where we own 10 weeks of a villa, to use a villa in Hilton Head, South Carolina. So there's many, many Canadians that own property in the United States. And how best can people be prepared to deal with, what happens to life if somebody dies prematurely when you sell a property? And I don't want to get confused with too many issues, but David, what's the number one thing you believe that Canadians should be aware of when they buy recreational property in the States?
So I've seen several different kinds of situations that come across my desk. I would say probably the most popular form of ownership would be joint ownership by a husband and wife, which means they own it jointly with the right of survivorship.
And so the ownership is in that basis. Now, what happens upon the death of either spouse when it's joint ownership?
So in this situation, the first death is the uncomplicated part, because all that one would need to present to the county clerk, so to speak, is an affidavit with a copy of a death certificate, which means then, because of joint ownership, title vests in the survivor. So there's no need to have a South Carolina will, a Florida will, or ancillary, what we would call ancillary administration in either like South Carolina, North Carolina, or Florida to get title into the survivor's name. Just by virtue of the form of ownership of joint ownership, the presentation of a death certificate and filing it in the county clerk's office so it's publicly available means that title will have passed to the surviving person.
Right. But recognizing in Canada, when the second spouse dies, it's not as simple as when the first spouse dies. And the same thing, I guess, would apply in the States.
That's where the problems arise. Okay. So when only one person owns the property and that person passes away, irrespective of whether there was a surviving spouse or not prior, then in that situation, you're left with some form of estate administration in the jurisdiction where the real property is located, whether it's Florida, South Carolina, California, wherever. So this is where it gets to be time consuming and expensive. So, is there an alternative to estate administration? And there are a couple of examples of how to avoid that. In Florida, where I'm licensed to practice, Florida allows the use of what is called an enhanced life estate deed, which means the husband and wife who own the property as joint tenants can name some or all of their children as remainder beneficiaries. And in that situation, all that has to happen is when both parents have passed away, 2 death certificates are supplied to the clerk's office with an affidavit, and then title vests in the named beneficiaries. That's one way. And another way of doing it is, instead of having title in the name of the husband and wife or the parents, from a Canadian perspective, assuming that the parents are over the age of 65, you can use a local revocable trust, which is a disregarded entity for tax purposes on the US side. And I believe
Disregarded means you don't have to worry about tax.
Yes, you don't worry about tax. And
that's what I thought. I just wanted to clear.
Right. And what it does is it passes title to the named residuary beneficiaries named in the trust. So that's a way of avoiding the time-consuming and expensive process of estate administration in a local jurisdiction.
Does it eliminate any tax impact that would occur if upon the death of an individual after their spouse had passed on, and that individual's estate sold a property? With what you just outlined there, does that minimize or eliminate or mitigate any of the tax issues?
It doesn't. It really has no effect on tax issues, because it's as if the individual person owned the property directly. Because of its nature as a revocable trust. So whether or not there are both the husband and wife alive at the time of sale, or only one person is alive at the time of the sale, or both have deceased, the possibility of U.S. estate tax remains the same. It's just a device to eliminate the necessity of this estate administration process.
Right. Okay.
A title issues, basically. The
which
tax
is
issues remain.
Right, which is a significant benefit if you can make the transition in ownership in a simpler way, but you still have potential tax issues to deal with.
Yes, even in a simple case,
yeah,
with relatively modest amount of assets, the cost of ancillary administration in a foreign jurisdiction like Florida or South Carolina could easily be $5,000 to $7,500 US, just because of the process that you need to go through, whether it's a $200,000 condominium apartment or a $3 million. There's a certain amount of work that has to be done, certain number of steps that have to be taken, hoops to go through, etc., until you're out of, or you've completed ancillary administration.
So recognizing the information that we're discussing is strictly for information purposes, and don't take any of this information and try this at home on your own. You need to seek out legal advice on these particular issues. But David, I can see some people watching us, our discussion today, or listening to our discussion and going, oh my goodness, wow, this is complicated. I'm not going to worry about it. Can you contrast that? I don't want to worry about it. In other words, you don't want to spend some money now or spend time in getting the clarity from an estate planning purpose. Can you contrast that exercise of being prepared properly, having your family prepared properly, versus what happens if you haven't dealt with it in a planning perspective?
All right. So I would break this into 2 parts. There's the lifetime experience, and then there's after lifetime, or in the event of death. So most times people buy property, maybe it's not their intention to own it forever. So it's not going to become some family monument, so to speak. So at some point it's likely to be sold. And if they own it for 5, 10, 15 years and sell it, and not a problem. It's the unusual or the rare circumstances that can come up that can be a real problem. So even when people have not passed away, there are other, shall we say, potential casualties that could befall them. One is lack of capacity, dementia, Alzheimer's disease. So having title in your name is, great from an ownership point of view, but if you can't write a check, you can't function. You need to have a local, like in Florida, a Florida power of attorney and or a Florida healthcare proxy to deal with not only property issues, but financial issues, as well as potentially insurance issues, a variety of different issues that come and are part of the ownership of real property. Things that we can't predict, but if you're prepared and you have these relatively simple documents done, a result can be achieved easily and inexpensively. Because if you don't have them done, and both, let's say both owners become incapacitated because they've owned the property like for a long time, and neither one of them is competent, then you might be faced with having two local guardianship proceedings. And it's time-consuming, expensive, and I'm not talking about Britney Spears either. So it can be challenging to unwind a situation like that without the proper documentation.
So let's talk about the proper documentation. So you're saying to our listening audience that for those of us that own property in the States, you should have an attorney, a power of attorney for property, a power of attorney for personal care, like we would have in Ontario. You should have the same thing in the state where you own property, where you own real estate.
Correct.
And
in addition, you might also, depending on your time horizon for the ownership of the property, even if it's relatively short, it wouldn't hurt, depending on how you're owning title, to have, as an example, owning property in Florida, to have what I would call a Florida real property only will, to avoid the need of having ancillary administration, which briefly means for Canadians residing in Ontario, if somebody passes away, their will in Ontario needs to be filed with the Ontario Probate Court.
Right.
A certified copy of the probated will and the authority of the executor trustee then gets shipped down to Florida and filed with a petition for administration. So to avoid those steps, you could just have a Florida real property will or a South Carolina real property will and avoid the need for having the Ontario will filed in this local jurisdiction.
Fascinating. Absolutely fascinating. So in this case, we're talking about you were talking about in effect, a special will for your real estate in Florida as an example.
Right.
Right. And we were talking about the powers of attorney that you should have. So, but if I'm from Ontario and I own property in Florida, how am I going to go about finding power of attorney in Florida? We need to find a Florida resident to act as that.
Well, you need to find an attorney who's licensed to practice in Florida. I mean, they don't all have to live in Florida and have their office in Florida. We have our office in Buffalo, but I'm licensed to practice in Florida. And I'm doing Florida documents in Buffalo, New York. And periodically when I'm at our office in Burlington, I'm having them signed in Ontario. Okay. It's just a Florida document where the place of signing or execution is different from perhaps the area where it's being used. It can be signed anywhere.
So I get it. So the lawyer, people like yourself and your firm could be the power of attorney for property. I can see that. But what about the power of attorney for personal care? I look at my own situation. My oldest stepdaughter is a doctor. certainly would want her to be involved if something was going on with her mother or me in the States. But you're not a medical expert.
No, but those kinds of documents are creatures of state law. So, an Ontario personal care document obviously is going to be effective in Ontario. Whether it's effective in Florida is questionable. I mean, in the sense that in order for it to be properly authorized, you might need two legal opinions. One from an Ontario lawyer that it was validly executed under the laws of Ontario, and a second from a Florida lawyer that a foreign healthcare proxy or personal care power of attorney is effective in Florida. So why go through the trouble of hiring two sets of lawyers when you can just have a Florida document that's effective in Florida, prepared for you as a Canadian resident owning property in Florida, and have it signed in Toronto or Burlington or Guelph or wherever. But it's obvious going to be effective in Florida. And so for families that own multiple properties, they need to be equipped with multiple documents on the unlikely event something difficult might befall them. So you just need to be prepared to have the right arrows in your quiver, so to speak, so that you can adjust to a changing environment.
Okay. I was listening very carefully to everything you said there with that answer. I'm not sure I got everything. But so I get I understand how you in Buffalo, licensed in Florida, could be power of attorney from a property point of view. But the question I asked was, and I couldn't connect the dots of your answer, I guess, was with regard to the power of attorney for personal care. And we have so many Canadians that spend up to 6 months a year in Florida, that I would hope they're all prepared that in the event of incapacity, that they have the right documentation, that they can be treated properly and have proper the direction by the appropriate family member.
Yeah, well, in order for the document to have effect, the simplest thing to do is to have a Florida document and not rely on an Ontario document, because...
Can the Florida document mirror the Ontario document as far as the person who would be the power of attorney?
There's no
great.
There's no restriction on who you name.
Okay. That's much easier than I understood it to be.
That's very simple.
Okay.
There are, let me just make one small observation, and that is, if you decide to use this Florida real property will, or a South Carolina real property will, or instead of the sunshine in the winter, you're a skier and you have a place in Ellicottville, New York, okay? Each state has different rules as to who can be an administrator of an estate, and they're all different. There is nothing uniform about qualification. So you need to be careful about who you name, what kind of people you're going to name in these local wills. So there is differences among all 50 states.
So there's no question here. There's no question. There's no way of dodging this. If you want to be organized and properly prepared for any eventuality, you need to connect. Canadians need to connect with a U.S. lawyer who has the appropriate knowledge and experience with regard to working with Canadians on cross-border issues. And right now, we're just talking about property. We're not talking about owning businesses, and we're not going to get into that today. We're only talking about owning property, that you need to seek out that legal advice. And David, with the advent of the technology we're using for the video part of our call, it's pretty easy for you to connect with Canadians.
Right. We do Zoom calls all the time. especially when the border was closed, but now that it's open, I mean, we do have an office in Burlington, so I'm there periodically. But technology makes communication a whole lot easier.
Certainly
like
a whole lot easier. Absolutely.
Yep.
Absolutely. So we're talking about powers of attorney in the event of, you're unable to act for yourself. We talked about passing on the property to family members. But with regard to tax, and we did say that whether you pass it on to family members through that administrative process, that's much easier than it would be if you didn't have that structure, but there's still a tax to deal with, and to be aware of the tax implications, and whether you're going to be affected by them or not, it's a different story. But in Canada, upon your death, you're deemed to have sold all your assets on the date of death, and any of your assets that are of capital in nature and have had appreciation are subject to taxes on the capital gain. In the States, it's different.
Yes, it is different. To a certain extent, there are similarities. What you just described in terms of the deemed capital gains tax in Canada is deferred if there's a surviving spouse who's receiving all of this property.
Right.
So we have a similar concept in the United States, which is called the marital deduction, which is unlimited in size. So whatever assets are passing from one spouse to another, either by will or by operation of law or beneficiary designation, all of those assets are exempt from estate tax by virtue of this marital deduction.
Right.
So,
but upon the death of the second spouse.
Yes. So that's where it becomes a taxable event, most likely. There are certain refinements in terms of the marital deduction, in terms of a limitation for non-citizen spouses, but I don't think we need to get into that. That's perhaps at a different session. But in what you describe as when there is only one person who owns the property as a result of a prior death of a joint tenant, then you have the situation where estate tax, U.S. estate tax, might be imposed. So as a Canadian citizen owning property in the United States, that person is a non-resident alien. So under the Internal Revenue Code, non-resident aliens are only allowed an exemption of U.S. source assets whose value does not exceed $60,000 U.S., except if there's a treaty. Well, fortunately for Canadians, there is a treaty called the Canada-U.S. Income Tax Treaty, which allows Canadians a portion of the U.S. estate tax exemption. So there is a formula that is used to determine what is the slice or portion of the U.S. exemption. Right now, the U.S. exemption is somewhat of a moving target. It's fixed now between now and December 31st, 2025. If nothing happens, it reverts back to the exemption that existed in 2012. The current exemption this year is slightly in excess of $12 million on a per person basis, for which Canadians would get a portion of it based on this formula.
Right. And is there any way to say, to provide a general rule? I'm sure as a lawyer you would hate to provide a general rule, well, but if I'm sitting in Canada and I own a condo in Florida worth $600,000 US, and my overall assets are $3 or $4 million, would I have to worry about taxes, or it's just you need to go through the methodology or the formulas to determine that?
So my usual cutoff point is $500,000 in real property value and somewhere between $4 and $5 million in what is called worldwide assets.
Right.
So worldwide assets is a slightly different concept for Canadians as compared to the deemed capital gains tax, because it includes life insurance, because life insurance is generally not part of the deemed capital gains tax calculation.
It's not at all, no.
Okay, but it is for purposes of this formula. So if your real property in the US is over $500,000 and your worldwide assets are over 4 million, then that's the point I would do a calculation, which means I need an inventory of both the husband and wife's assets, assets that are owned in each name, current values, and joint assets. And then a calculation would be done to see, is there an estate tax upon the first spouse's demise, or is the estate tax only going to occur on the second spouse? And if so, how much? Maybe there's none because of this relatively high exemption. But then not knowing how long the property is going to be owned and not knowing what's going to happen after December 31st, 2025, there's a lot of unknown elements here to try to evaluate.
Yeah, you know, the both governments on both sides of the border have complicated tax acts. There's no, they just get more and more complicated all the time. More and more legislation is added in, and it really is not simple at all. That's just the reality, and we can't do anything about that. But we can do something about the planning. And that's where you come in, David, and people like yourself who are attorneys or lawyers in the United States and understand the impact on Canadians of owning property in the States, that people should reach out to somebody like you. And recognizing you're in Buffalo and you have an office in Burlington, that's a convenient thing for people. But you know, I hopefully the people that have been listening and watching have got some value out of this. But I think for me, the value is this is generally not simple, and that you want to make sure that the estate administration and the powers of attorney are properly documented, so that there's no issue for anybody upon if you're unable to act for yourself, or upon your passing, that the process of transitioning, and in the case of being disabled or being unable to act for yourself, the proper tools are in place that can allow somebody to act on your behalf. And that upon your passing, there is a process in place that's going to minimize the impact on the survivors in transitioning your assets and recognizing there could be some tax implications.
Right, I would agree. And you need to have an effective game plan, and this tends to be somewhat of a collaborative process involving lawyers on this side of the border with their advisors on the other side of the border, chartered accountants, Ontario lawyers, etc., just so that there's a clear path in terms of ownership and future ownership, so that there aren't any hiccups along the way.
David, I want to say thank you very much for taking time to provide some wisdom and insight and perspective on these particular cross-border issues for Canadians owning property in the United States. You obviously know your stuff, you're seasoned, you're experienced, and you got a lot of perspective and wisdom to share. So David, thank you very much for being a guest today. And I want to say thank you to people that are either watching on YouTube or listening in all the other channels with regard to the podcast. And David, once again, thank you for your contribution to our discussion today on the Mayor of Money. And let's go Bills.
Right, Rick, thanks very much for the opportunity. Let's have a good football game.
Absolutely. Thanks, David.
Thank you. Bye-bye.
Bye-bye.